Thank you. This pre-trial review is the matter of case number CFI 045-2022 and is being held by way of video conference before Justice Michael Black, appearing from London. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Gately UK LLP. Lead counsel is Ms. Sarah Malik. The defendant is represented by Clyde & Co. Lead counsel is Mr. Gavin Mansfield, KC. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
I'm not sure it is. I see Mr. Sethi on. Am I correct in assuming that you're leading Ms. Malik? So you're muted, I'm afraid.
Apologies. Yes, Judge, that is correct. I'm leading counsel for the claimant, but Ms. Malik will be conducting the advocacy today.
Okay. Well, with that amendment, I'm happy to confirm that the statement was correct. Right, shall we move on then?
Your Honour, I'm Mr. Kent, junior counsel for the defendant, and I have a leader, Mr. Mansfield, KC, who was tuned in, but his camera is turned off. Well, you can see that on the screen.
No, I can see Mr. Mansfield perfectly well. He's muted. He's muted, but he's not. His camera is on.
Judge, Your Honour, I can hear you. I'm sorry for not introducing Mr. Kemp myself. Hopefully you can both hear and see me.
Well, I had the pleasure of Mr. Kemp before me on the previous occasion, so I know he's representing the defendant. And thank you all for your helpful submissions. If I can just summarise where I think we are, and you can tell me whether I'm right or wrong. I think there are probably 4 broad subheadings to deal with today. Firstly, the re-amended defence. I don't think permission's been given for that yet, and there would have to be a re-amended reply. Secondly, I think I'd like an update on where we stand on the bundles. And thirdly, I'm not sure, again, that the old case management order, which had a slightly different date for the hearing, still is correct in terms of when the skeleton and chronology might be served. And fourthly, there are hearing issues. I've got 4 hearing issues. One, the length of the hearing day. I think claimant has been rather ambitious there. Secondly, the trial timetable. Thirdly, question of video evidence. And fourthly, question of whether or not there's going to be a live transcript. Is there anything else to add to that list? Ms. Malik, if you want.
Your Honour, no.
No, and Mr. Mansfield?
Your Honour, only this, that in your issue 4 hearing issues, sub-issue 3, which was video evidence, I mean, that's an important issue to us. We are going to invite you to reconsider the question of having the whole hearing remote, or in the alternative, a hybrid hearing.
Yes, I mean, again, let me go straight to that because it's the most contentious issue, and it's one I have to say that I have quite a strong view about. Given the nature of this case, if it were an ordinary commercial case, I'd have no hesitation whatsoever in dealing with it all remotely. But I think so much turns upon the oral evidence in this case, and the oral evidence of the claimant and some of your witnesses, at least, that I did consider that perhaps unusually, because this court tries to do as much remotely as possible, that this should be an in-person hearing. I am quite content, subject to anything Ms. Malik might say, that if individual witnesses can't make it for good reasons, then we take their evidence remotely by video. And so where I'm at is a remote, is as a hybrid hearing. Mr. Mansfield, do you wish to try and persuade me that my view is wrong on that?
Well, I'd be grateful, Your Honour, of the opportunity to do so very briefly, and I'm very grateful for your preliminary indication. I'm happy to address that now, or take it in the sequence, Your Honour, that you.
Let's do that now, because I think it's the most contentious of all the issues, and let's get it dealt with.
Indeed, Your Honour, yes. And I'm just going to make a few points briefly, if I may.
Yeah, of course.
There is a witness statement.
I've seen that and read it.
I'm grateful for that, and that sets out the position in relation to our 8 witnesses.
Yes.
You'll see there that the position breaks down as follows. 1, whilst it's inconvenient for all witnesses, 4 of our witnesses can, if required to, attend in Dubai. 4 of them, that is much more problematic, and they can't, of whom 2 are no longer the bank's employees. So it's there's a difficulty for us. You'll appreciate, Your Honour, that this hearing was listed as a remote hearing back in November, and we've been preparing on that basis. So all of my witnesses are outside Dubai. They're either in Singapore, Germany, or the UK. And we're reliant in particular on those who are no longer our employees for their willingness to attend trial and give evidence. We can't witness summons someone outside of the jurisdiction. So at this distance from trial, it is going to be extremely difficult for us, particularly with those who can't attend. And Your Honour, you've already indicated, well, that may suggest that the right way forward is a hybrid hearing rather than a fully remote hearing. But I'd ask you to take into account these factors. First, although I understand, Your Honour, you're concerned that in a case that turns on contested oral evidence, one might be assisted by having a hearing in person. And obviously, Your Honour, it's a matter for you because you're the judge that's going to be hearing the witnesses and deciding it. Since the pandemic, life changed a lot in terms of how we deal with oral evidence, and we've all found that as counsel, and if I might say so with respect, I think judges have found that it's easier than we would traditionally have thought to assess evidence remotely. You've already indicated the point, Your Honour, that the vast majority of hearings in this court are dealt with remotely. But if I were permitted to make a comparison with the situation in England and Wales, were these proceedings being litigated in England and Wales, they'd be litigated in the Employment Tribunal. Certainly the London Central region, which deals with many of these cases, has barely returned to face-to-face hearings, even on multi-day contested trials, and there's been no difficulty in relation to that. So the first point we make is the technology has improved and we've all got used to doing hearings remotely, so there is no need for an in-person hearing as against the inconvenience that's caused. The second point is this, to consider that in a hybrid hearing, one then has an imbalance. You've got some witnesses there face-to-face whose evidence can be assessed in a traditional way, and others who are on screen. So there may be some merit in the playing field being entirely level, everybody being heard in the same way. But ultimately, Your Honour, it's a matter for you as the trial judge as to what you think the most effective way of determining the hearing will be. Were you minded to pursue a hybrid hearing, I'd ask for those witnesses who we've outlined in our statement to be able to give evidence by video link. And in consequence of that, and we will come to this, I'm sure, we'll need to think about the timetabling of when those witnesses would be able to join the hearing. Those are my submissions, Your Honour.
Thank you, Ms. Malley.
I'm grateful. Well, Your Honour, you won't be surprised to know that I'm going to disagree with my learned friend. I'm of the view that witness evidence needs to be tested. It needs to be tested in person. I don't agree that in a case like this, that a remote hearing or technology is adapt to see witness demeanour. Credibility is a huge issue. And with respect to my learned friend, whereas issues may be litigated differently in London, this is a test case in the DFC courts where the discrimination law is being looked at. It's an important matter for jurisprudence. The DFC courts are allowing witness evidence to be heard in hearings. I think there was a misconception by the lawyers of the defendant to suggest that the DFC court weren't having in-person hearings. We certainly know that's incorrect. In terms of the level playing field and whether some witnesses or whether the hearing may not be fair if there's a hybrid. Well, with respect to we disagree. The hybrid only needs to take place if all of those witnesses indeed, for good reason, as you identified, Your Honour, can't attend. And in the witness statement, which was received today and very late, we have 2 witnesses who no longer work for the defendant. And that seems to be the predominant reason why they can't attend, with another reason given that one is looking after an unwell daughter with no evidence to back that up. I'm not suggesting that's not the case, but just to put it out there in terms of why they shouldn't attend or could attend. And secondly, there seems to be an individual who can't attend because he's holding fort back in the legal team of the defendant back home. But his boss, who in fact instructed him to do everything, can attend. So one may question whether, in fact, he should properly give evidence if he's able to attend, and everything the witness says who can't attend is something he's been instructed to do in any event. Our submission stands. It is an important case. It's not unheard of for hearings of this nature where there are cross kind of jurisdictional, well, not cross jurisdictional issues, but certainly witnesses in different locations. For them to, it's not the first and last time that they'll have to attend hearings abroad. So all of the points my learned friend makes are rather, well, we've kind of evolved and we don't need to have in-person hearings. It's inconvenient. That, Your Honour, is not, I submit, made out, because it seems to be a position where they say 4 can attend, 2 can't because they're no longer with us. But again, I don't have access to whatever the agreements were when they terminated or when they departed. But usually employers do insist that there's any investigations or legal hearings or otherwise, employees do comply. However, as my learned friend has said, rather in your hands, Your Honour, I don't want to repeat the submissions that have already been made or the emails that have gone to the registry in this respect, but we do hold strong that the claimant has the right to have this witness evidence tested in person, and it just doesn't do the same justice remotely at all. If I may assist you no further, those are my submissions.
Thank you. Would you like to say anything in reply, Mr. Mansfield?
I'm grateful, Your Honour. Very briefly, I just want to pick on the point the learned friend makes about the witness in Singapore who's holding the fort, as she puts it, because it does illustrate one of the difficulties we face. That's Mr. Coe. His witness statement, the PDF of his witness statement runs to a total of 5 pages, including the heading and the back sheet. So it's about 10 or 11 paragraphs of evidence. It's evidence that we want to call, but to require him to come from Singapore with all the travel and expense that's involved and the time away from the office to give that evidence and be cross-examined for I know not how long, because the claimants haven't engaged with us on the trial timetable, but one can't imagine it's going to be very long, is grossly disproportionate to the issues that the court's going to have to determine. So in addition to the points I've already made, there is a cost and proportionality issue in relation to the attendance of a number of these witnesses.
Thank you. Thank you very much. Look, I don't want anybody to think that I can't be shifted in my views, but on this occasion, I do consider that at least as much of the evidence as is practical should be heard in person. I certainly take on board what Mr. Mansfield has said, is that the technology has improved a great deal, and within this court we have had contested fraud trials remotely during COVID, and indeed it's one of the court's key performance indicators that 80% of its hearings should be undertaken remotely. On the other hand, I think the suggestion that there isn't a level playing field if it's partly remote and partly in person is slightly inconsistent with the first point. I think that the playing field it will be level, but on the other hand, I'm not minded to accede to Ms. Malik's submissions that I should be insisting upon people who find it difficult to attend, particularly Mr. Coe, who apparently is not a major witness in this case, and even more particularly the former employees of the defendant company. So I think that where I started is where I finish, that we are going to have a hybrid hearing, but I'm not going to insist, even if I could, and I'm not sure I can, that the witnesses who say they're unable to attend do attend. They will attend. They will attend by video. I'll come back to the practicalities of that in a moment when we deal with the other hearing issues. But that's just so we know where we stand and the shape of the trial as we go into the other issues. So can I move on then to the re-amended defence? I don't think permission has been given yet for the re-amended defence. I assume it's not contested, and I assume, Ms. Malik, that you want the opportunity to re-amend your reply.
That's correct, Your Honour. So we had the re-amended defence following witness evidence, where the matters that were previously not admitted have now been put into context in inverted commas. We were asked to concede the position in terms of not having to make a formal application to the court, obviously to assist the court, and an opportunity was given or proposed for us to have an opportunity to reply. And on taking instructions, that was agreed, subject to a caveat that we laid down a marker in respect of this re-amended defence and what actually came out. But certainly from our side, you don't have resistance in relation to them putting that in. We obviously have the opportunity to reply to that. And I think the parties have agreed a date by which that shall be done.
Are you going to tell me what the date is?
If I recollect, and I may be wrong, and I stand to be corrected, I think we've said the 15th, but I might be wrong there.
Okay. So that's 15th of May. Right, 15th May, 23, re-amended defence. Okay. Now, the next issue I have is bundles. Again, I think, from your pretrial questionnaire, Ms. Malik, that it suggested that the bundle will be ready by the 5th of June. Is that correct?
That was initially, I think that was the position, and that's because we were asked by the court to kind of follow the timetable as much as we could, or the RDC. I should say at this conjunction, I probably should have raised it at the outset. There will be, and the opposition are well aware, that there will be some additional requests for disclosure that have come about owing to the re-amend of the defence and owing to issues that are now being admitted that previously weren't. That hasn't yet been put together, and we are told by the other side that they will, well, they'll wait to see the application, or they'll wait to see what we want, but they will, for example, object to, you may well have seen there was some further disclosure, a redacted grievance of a third party to the bank, which referred to the claimant as well. And that grievance laid out names that the claimant had been called, namely Gorilla. And it was raised in that grievance, and we asked for the full version of that grievance because we understand from the claimant that there's other evidence in there that is relevant. Their position...
that's a bridge that we're going to have to cross when we come to it. But just in terms of the bundle, that shouldn't delay the preparation of the bundle. We can always add additional items.
I take that point, Your Honour. It depends if there's a lot of kind of to and fro between the parties in respect to that disclosure. We could start the bundle, and as you say, because they are e-bundles, they can always easily be added to. I do say you're unlikely to have a final bundle on the 5th of June for sure, because of that reason, unless the parties are able to kind of cooperate in relation to that disclosure.
Well, I don't see that reason. I don't see that reason is one for delaying the other documents after the 5th of June.
No, there shouldn't be any delay on that respect.
So we'll have a bundle then, but for those documents on the 5th of June. Those documents, we do not know yet whether they will be admitted or not. If there's going to be a contested hearing, I'll have to address that in due course. So then I can take it that we will have a bundle, but for those documents on the 5th of June.
Yes.
Okay, good. The earlier CMC order, which had an earlier trial date than we have at present, provided for skeletons and chronology on the 26th of May. That's obviously not going to be achieved. So again, Ms. Malik, what do you suggest by way of a date?
I think that's been superseded, and again, I stand to be corrected, but somewhere I recollect that 13th of June is now the date that's been provided and agreed. It's within an order, if I'm not mistaken, but that was superseded to the 13th of June. That's the date for for exchange 1 week before the hearing date. Email that was sent by the registry, as I understand. I'll try and dig out.
Okay, I didn't pick that up. Mr. Mansfield, do you know anything about that? Or
I don't, Your Honour, but it sounds sensible. That may well be the position, but I'm just not up to speed on it. I can see in tab section C of the PTR bundle, there was an order in March by consent that had adjusted the date for reading list. Doesn't deal with and witness statements. Doesn't deal with skeletons, but it may be there's another order that my learned friend knows about that I haven't seen.
There's an email. I've asked for it to be forwarded, or at least a date, so we can hopefully access it. There is an email that came from the registry in relation to dates.
Okay, I'm being told by Mr. Kemp that there has been an exchange about that, and that's right.
Okay, good. So 13th of June is agreed. That takes me to the other hearing issues. Ms. Malik, you suggested that we sat between 9 and 6 o'clock in the evening. We're not going to do that. The normal sitting day in this court, like England, is 10 to 10, is 10 to 4:30, occasionally to 5.
I hadn't understood that had made its way to the registry. In fact, we'd had the other side's timetable. One of the juniors had put something together, but I didn't know that was before the court. Just so you're aware, Your Honour, in terms of the timetabling, and it is an issue because the other side have kind of put some pressure on to say we need to know exactly when you're wanting witnesses, and what we have from them is just half a page of we want 2.5 days with the claimant, and then they've given us some time with the defendant's witnesses without really timetabling, and my practice usually is subject to what the court would like, but certainly in the arbitration.
What the court would like would be for the parties to agree a timetable that suits the diaries of those people who are going to be giving evidence remotely. If you can't agree, then you'll have to come back. But I think at this stage, I would hope that experienced counsel on both sides would be able to agree a timetable that enables the witnesses to meet their other commitments and also to be satisfactorily cross-examined in the time.
Your Honour, we can. We just asked for, we don't obviously have the reply witness statements yet, which is the 17th of May. We've had a re-amended defence, so I just wanted some more time before we can really pinpoint exactly how long we need with each witness. Of course, we'll work towards those who are not attending and be able to give some clarity as to the days we would require them or the timing, but to suggest, and it was the opposition's position, this should be before you today, we just said that that's not going to happen because we're not fully appraised of the witness evidence and nor the pleadings, which have yet to be amended, or certainly our replies to come in. So if we may agree, or if I don't know if the court can direct that, at least until we've had the additional witness evidence, i.e. the reply, we've had the amended reply to defence, then we can at least timetable how long we need with each witness. And I also do need to take instruction from lead counsel on this as well. So
okay, so when do you think you'll be in a position to agree a trial timetable?
If I just may take a minute to look at the diary now before I give you a date. If we have probably, hopefully, the week of, if we have the reply statements, definitely the week of the May the 22nd, during that week we can, because by that time we've had the reply witness statements and we've had the amended, we've had the reply to defence in as well. And it's 1, 2, 3, it's about 5 weeks before trial, or 4 weeks. So if we say the week commencing 22nd of May, I don't think that should be an issue, certainly from our side.
Mr. Mansfield, it doesn't sound too unreasonable.
No, Your Honour, I'm just checking the calendar. I mean, from our point of view, the sooner the better. I take my learned friend's point. We put a timetable in because we understood the requirements for PTR was for the parties to have discussed and put forward a timetable. So that's what we've done. But I can I hear what my learned friend says. I must say, I struggle to see how our amendments are going to make any difference to the question. There's a small number of points in the re-amendment, and some of them are admissions, but I hear what she says about reply statements.
Yes, it's all about the art of the possible at this stage.
Yeah,
and
absolutely.
The week commencing 22nd May is not going to hugely inconvenience anybody, I hope, from today's date. So I think that's fine. And that does lead me on to the two associated points I wanted to make. I have to say this court's video protocol is slightly out of date in the RDC, and it will be changed very shortly. But can you please look at and use the English protocol, which I think is practice direction 32, isn't it? The annexures practice direction 32 in the CPR, just from recollection. In agreeing, again, I hope I can leave it to the common sense of the parties to agree a protocol. If not, then of course I'm here and will address it at short notice. But it seems to me there's very little point in us reinventing the wheel when it's been done in England. Any observations?
Your Honour, no, I think the parties have endeavoured, even well before this hearing and all of the hearings we've had, is to try and come to as much agreement as possible. So we will follow that same line of thinking, and I really think agreeing a protocol for video evidence is not that difficult.
Okay.
Given what we're dealing with.
Well, good optimistic submission there. Mr. Mansfield, anything to add to that? Or?
No, Your Honour, this is my first hearing in the case. I approach it with a tone of optimism throughout, so I'm sure we'll be able to sort these matters out.
Good. And the only other point that I wanted to cover was what are we doing about a transcript?
Your Honour, I haven't taken instructions yet because obviously it comes with a cost.
Yes.
And I need to speak to the claimant and probably get some costings from the registry, which we usually take in advance. I say without instruction, I say out loud, it probably would assist, but again, I need to take instruction on where we stand with that.
Well,
and again,
it's as far as I'm concerned, a daily transcript is not optional. I definitely need that. In an ideal world, I would like a live note, but that does come with it with a significant additional cost, and I recognise, of course, that the claimant is an individual, not a large corporation. But particularly in a case with strongly contested evidence, transcripts are rather important.
Your Honour, leading on from that point, and in fact, just Andrew Winding as well, to the proposed timetable of the defendant, I do note that they've left within their proposed timetable, and we will obviously discuss it, 2 hours for closing submissions for each party. I don't know what your practice is, and I don't know if the court would be assisted in a case like this to have written submissions if need be to wrap it up. And if we have a transcript, obviously it makes it easier. Closing submissions of 2 hours is fairly lengthy, but again, I'm in your hands.
Well, I'm not sure that's right, actually. This is a case that is bristling with points. And there will have to be submissions on the oral evidence and submissions indeed on the authorities, in particular the English authorities, about how far one gives weight to oral evidence against written evidence and so on. So I would expect to be addressed upon all of that. Sorry, just let me finish if you may. So what I would expect to do is to see how we got on and see how much time we had left. And really what I wanted to be addressed upon, and if, for example, I did feel that longer oral submissions were necessary, but after the service of any points or skeletons, we can discuss the form of them, then we might adjourn the oral submissions to a remote hearing. at a later date. But I'm open to all of those suggestions and play it by ear, really.
And does that then, I take, include possibility of written submissions? A court may or may not order those at the end, depending on where we.
I think it's likely that I would be asking for something in writing, if only a skeleton, before oral closing submissions.
I'm grateful, Your Honour.
Things would go, I think, more efficiently in that way. Again, any observations, Mr. Mansfield?
Well, Your Honour, I hear what you say, and I accept that to an extent we'll need to play it by ear, but we're keen that the hearing gets concluded, including its submissions within the listing, and we endeavoured. I wasn't present, but I know the case management hearing canvassed how long the hearing needed to be to resolve the issues. There are a lot of issues. The claimant's original time estimate for the trial was 2 to 3 days. We thought it was going to be rather longer, and it's listed for 5, but we would be keen, if at all possible, sensibly, to get to the end of submissions by the end of that listing.
Well, I hear that, and it would be good if we could, but I'm willing to keep the door open if we don't make as much progress as perhaps might be anticipated. But we will play it by ear. So look, those were the issues that I wanted to cover. Anything else arising out of what we've discussed, Ms. Malik?
Nothing that comes to mind at this stage, Your Honour. I'm grateful.
Thank you. I don't know whether your leader has anything that he would wish to add.
The floor is his.
No,
Mr.
thank you very
Sethi.
much, Your Honour. I do not, thank you.
Okay, thank you. And Mr. Mansfield, anything that you'd like to add?
2 points, if I may. I've just checked the registry's correspondence around the deadline for skeletons.
Yeah.
And this is actually goes back as far as the 3rd of November, when the dates of the trial were listed.
Okay.
The direction that was made was for sequential skeletons. The claimants on the 13th of June and ours on the 14th of June.
Okay.
I think and we'd invite you to leave that in place.
Yes, that's fine. Okay.
Your Honour, we did at that stage ask for simultaneous. There is correspondence, and I don't know if that was dealt with by the registry. I think the end email does say 13th and 14th. My learned friend is correct, but we had asked for simultaneous.
Okay, but well, I'm not going to reverse the order if it's a reasoned or rational decision of the registry. I have no reason to overturn it. And the second point, Mr. Mansfield, you wanted to make?
About transcript, my instructions go so far as saying that we are keen to have a transcript. I have to say I don't have specific instructions on the point, Your Honour, that you raised as to whether that's daily or live note. In any event, I take your point about the claimant being an individual, but nonetheless a senior and highly remunerated one. So we would look, whatever arrangements we reach, we'd look for the cost in the first instance to be shared, subject to recovery at the end of it. I don't think you need make a specific direction about that now, but I just wanted to indicate what our position was.
Yes, no, I agree. As I say, with experienced teams on both sides, it's certainly not my practice, at least initially as PTR, to start imposing things that people can discuss. But you know, if discussions are not fruitful, I'm very happy to impose my will in due course. Okay. Anything else at all, Mr. Mansfield?
Well, I just take a moment to check with my team in Dubai.
Yes.
I'll just send a message if I may, but I think not. Nothing further from me, thank you.
Okay, well, anyway, well, thank you very much in that case, all three of you, although Mr. Sethi's played a silent part, for your submissions. I think just running through then, we are agreed that there will be a re-amended reply served on the 15th of May. The bundle, subject to any additions, will be served on the 5th of June. Skeletons and chronologies, claimant 13th June, defendant 14th June. And we are going to leave it for the time being for the parties to discuss the trial timetable. It will be a hybrid hearing, and the parties are also going to discuss the nature of the transcript for that hearing. I think that's probably it, isn't it?
Yes.
Yeah, great. Well, again, thank you all very much. And subject to you not agreeing things, I'll see you at the trial.
Thank you.
Thank you very much. Right, good day.
Good afternoon.